Everyone. We are calling this meeting to order at 9:05. This is the Physical Therapy Board meeting on September 15th. Can we start with roll call?
Tanya McMillian,
Present.
Dale Armstrong, Karen Brandon,
Present.
Katarina Ellaby,
Present.
Samuel Q,
Present.
Alicia Ben Ahmed. Here. All members are present and the board has a quorum.
Thank you. We're moving on to agenda item number 14, a reading of the board's mission statement by Member Brandon.
The mission of the PT Board of California is to advance and protect the interests of the people of California by the effective administration of the Physical Therapy Practice Act.
Thank you, Member Brandon. Moving on, agenda item 15, a presentation. And Michael, notes, please. Federal Military Spouse Licensing Relief Act.
Good morning, everyone.
Good morning.
Always a honor and pleasure to be before the board. I don't get to talk very much sometimes at these meetings. You all do a great job, and sometimes the best part of being legal counsel is not having to do much of anything during meetings. But enjoy the opportunity today. So we're going to be talking about the Federal Military Spouse Licensing Relief Act, which became law when it was signed by the president on January 5th of this year. And it was sort of an interesting surprise for everyone because it was put in the bill that did a lot of educational and health-related things for service members and veterans. It was snuck in there, as Congress likes to do, at the 11th hour, and we were a little taken by surprise, I think, across the department, in that no one really knew this was coming. So the act, starting on January 5th, permits military service members and their spouses who hold a license in another state to practice in California or any other state where they are ordered to serve, if they have a license within the same professional discipline and a similar scope of practice. So with physical therapists, we certainly have similar scopes of practice around the country, and it's sort of clear. There are some professions where it may not match up, and there may not be a equivalent license type in California as there is in other states. But certainly with physical therapy, there are licenses in every state for that. And so those individuals now who are usually probably spouses, because most of the time individuals who are physical therapists and are serving in the military are going to be using their federal exemption and practicing within the scope of their military duties on a base or likewise. But the opportunity's there if that would arise. So in order to qualify, the service member or spouse has to have a professional license issued by a different state, and they have to relocate to California because of their military orders. So that's a requirement that the military orders require them to live in California. They have to supply a copy of the military orders to the board, and they have to maintain, it's almost a legal fiction that they are practicing in California with a license from another state. So they have to have at least one license that is active and in good standing with their state. But if they have any other licenses, those also have to be maintained in good standing. And generally we think that means that their license cannot be subject to discipline. If it's inactive or retired, or in some other status, we still think that's a license in good standing.
May I ask a question?
Yes?
So if someone is licensed in Kansas as a PT and as an OT, PT license is in good standing, OT license has been disciplined, they still won't be able to practice PT in California?
They would be able to practice PT.
They would? Okay.
Because it's only applies to a license in the same professional discipline.
Gotcha.
But they could not practice OT.
Yes. Okay, thanks.
Yeah, and please do stop me as we go along, but we can also take questions at the end. Okay, next. There's a couple other qualifications. The first one here is they had to actively use their out-of-state license during the 2-year period immediately preceding the relocation. I think many of us have sort of scratched our heads at that, and I just presume that Congress wanted the person to be experienced, but ultimately, you know, we think that as long as they did one activity that was where their license was required to provide that service or perform that, you know, perform those duties, that would satisfy that requirement. And the Act also requires them to submit to the authority of the board for purposes of standards of practice, discipline, and fulfilling continuing education requirements. So a few things there. One, we can discipline these individuals. And two, in terms of the mention of standards of practice here, the idea is that if you were a physical therapist from another state and that state has a different scope of practice, or maybe there are some things you can do. I think dry needling is one thing that is a good example of that. And you come to California, you have to follow the California standard of practice while practicing here.
I have a question.
Yes.
So it says submit to the authority. Does this person now become licensed?
They do not.
So what are they?
Well, let me see.
To be discussed?
So the Bureau will not issue a license, and the Act doesn't contemplate any affirmative action by the board to permit a service member to practice, although interestingly, a bill was signed in California by the governor yesterday, which changes this a little bit. So I'll get to that in a moment. And in terms of enforcement, the board or bureau can take enforcement action against a service member or spouse that's ineligible to practice or does not meet California standards. So kind of at a high level, the idea here is if they're meeting the standards of the Act, that they would not be subject to a citation for unlicensed practice. If they're practicing and they commit misconduct in any way, or anything they do makes them subject to discipline, we can discipline them just like we would a California licensee.
No, I think we have a lot of questions, but I think I'm going to let you
Yeah.
go through because you might answer them and then we'll come back at the end.
Okay, so that's the end, or at least that was the end.
Until yesterday.
Until yesterday
Until yesterday.
afternoon, and we during our board dinner last night received the messages that the governor has signed SB 143, which is a budget trailer bill. And so because of that, it takes effect immediately rather than on January 1st. It creates a California statutory scheme that permits an individual to register with the board or bureau that supports the equivalent license that they have in another state. It's sort of interesting because it doesn't require them to register, but it requires the board to register an individual who satisfies the requirements of SB 143, which are that they, very similar to the provisions of the federal law, They have to hold a professional license in good standing with a similar scope of practice. They have to have relocated to California because of military orders, and they have to submit a copy of those orders to the board. They have to have performed at least one activity in the last 2 years within the scope of the license. And they have to keep each license that they hold in good standing. And in order to register, they have to submit to the board written verification or documentation from an on-licensing system to verify their licenses from another jurisdiction. And if a spouse, they have to submit evidence that they are married to or in a domestic partnership or other legal union with the service member. So there's a requirement to submit that and some other information. The board's required to register them within 30 days. And there's also a requirement for the board to post these individuals' names on their website, including the person's name, address of record, registration status, and the state name and license number of each license that they hold from the original licensing jurisdiction. So I think in practice, I'm not, we haven't fully analyzed this bill yet, and I'm not sure how the department will handle this, but I suspect they will be entered into the same licensing system and available for the public to verify on the normal licensing search on the DCA and on our website.
Mike, I have a question.
Yes.
So if they don't hold a California license and they're subject to discipline, how do we discipline them if they don't have a license?
So you just anticipate the, that's what I love about this board. You always anticipate the next thing I'm going to say, which is that they are deemed to be a licensee for purposes of standards of practice, discipline, and continuing education. So they also have to do continuing education to the same extent as a California licensee would. And one of the gaps in state law was it was not really clear under the Administrative Procedure Act that via state law we could take discipline against these individuals. Federal law certainly permitted it, but the provisions in the Administrative Procedure Act only speak to licensees. So this statute is really sort of the bridge between that, and it says that the board may take appropriate enforcement action against a person registered under the state law. We're not permitted to require a fee.
Ever?
Correct.
So,
For registering the out-of-state licensee.
so if they're here for 20 years, they can practice here for 20 years without ever paying a fee?
That's correct.
Assuming that the military orders cover that duration of time,
Yes.
yes.
Who's monitoring when they're done with their term or their tour, or their spouse is done with their tour?
Well, I think that's in terms of the federal law, that's the reason that the orders are required to be submitted to the board. And
So we're maintaining that.
we think that the orders themselves will describe when the end of the service will be. But that is certainly a concern, and one of the concerns that was raised in response to the federal law is how do we know when they're here or not? Because the interesting thing is under federal law, all they need to do is provide a copy of the military orders. So that suggests that regardless of this registration procedure, if they provide the military orders and don't want to cooperate any further, that's all they need to do. And the board would not be able to issue a citation for unlicensed practice so long as they're following all of the requirements of the act.
What kind of numbers are we thinking
Very small.
Jason? Okay.
So that's one thing that I'll let Michael finish, but I have a couple things, ministerial speaking, that I'll add to it as far as how the board will handle it with staff. But
Please go ahead.
the brevity of Michael's presentation is directly related to the federal statute itself, right? So the language in the federal statute is 2 or 3 sentences and a few bullet points. It's very simple. It has most of the onus on the licensee or the licensee spouse, meaning it's their responsibility to keep that license in good standing. It's their responsibility to provide those documents to us on entry into California. And this goes for any professional licensure in the state of California, not just the Department of Consumer Affairs, but the Department of Consumer Affairs, comprised of the 39 boards and bureaus, looked at that and said there are a couple things here that we'd like to add to it, hence this bill that was signed yesterday. I would say that we are all familiar with exemptions and expedites and things that we would like to extend as courtesies to our military service members. And this is just the federal government trying to remove some speed bumps for spouses, especially on deployments. Deployments can happen very quickly, very rapidly, and government doesn't react to that very well on the state level, right? And so this made, for them, a very simple solution. For us, I think we have everything that we need in the federal statute alone. Provide us with the military order. We can use that to determine what licenses they have in other states. We can see, and typically you can also see the start date and the end date of that military order, and if a military spouse is included in that order. So it's kind of a nice, all-encompassing document, but we also reserve the right for points of clarity in that statute where we can ask for, if it's need be, a marriage certificate or something like that to prove the military spouse side of things. Staff and on our side, when we receive one of those, and we have a few times now, would go in and look at, do they have licenses in other states, and would we consider those licenses to be in good standing? And to Michael's point, good standing mean essentially no discipline, no trouble. The license in the other state may be delinquent. That doesn't necessarily mean that they've done anything but let that license lapse. So I wouldn't consider that to not be a license in good standing. It wouldn't be a reason for me to say, no, you can't be here. You can't, I think it's unreasonable for us to say, go pay your fees in Texas so you can practice in California. But one of the licenses that they held has to be active and current. That's the trigger for them to allow through this federal statute to practice in California. The idea of us providing the information back to the public, I think, serves the consumer protection side of things, and that part is still being developed by the department. The intent is to create a web portal that essentially makes it that much easier for the military and military spouse coming in to have a central repository to essentially sign up as a registrant, provide that military documentation, and let us also turn around and take that and use it for the public posting for the consumer protection side. I think the undiscovered territory here is just the idea of registrant equals licensee for the purposes of things like discipline and continuing competency. That will have to just be kind of case by case tested as we come across those situations. There are a few examples in other areas of administrative law where temporary certifications have been treated as licensees and accusations are filed when it's appropriate and that kind of thing. It's a little unorthodox, but everybody tends to follow along, right? And with the federal statute as the guide, you could see the bridge. The federal statute essentially says submits to the authority. And so what we would, in the event that we received a complaint against a military member or spouse that was serving here under this exemption and we took action against them, we're taking action against their ability to practice under that federal statute. We don't call that a license. Now we call that a registration, right? The vacuum or the gap in between is there's nothing in the federal statute that says they have to adhere to the bill that was just passed yesterday, right? So they don't, if they just suffice and send me a military document, according to that federal statute, they can practice in California. Until some time that we say you're not qualified, right? We do a little checking into them. The registration, while it's provided as a convenience, could be this kind of place where people might fall between the cracks, right? They don't actually use that registration. They just send us their military documentation. In that case, we'll have to deal with that on a case-by-case basis too. There's always you can always ask them to fill out the registration. But with the registration comes some tasks, and some of those tasks are getting essentially endorsements from all of the other states that they might have licensure in, which can be burdensome and is not a requirement of the federal statute. So there's going to be some things that we kind of have to iron out over time. But again, this is a small enough of a population. And to, this board's credit, we've designated resources through military liaison, so we'll have a single point of contact for these folks to just naturally flow into that desk as well.
Just to add a little bit there, one of the things in the bill that was signed yesterday is they don't have to get an official endorsement to register for a license in another state. They can provide a copy of the other state's online lookup. The other point that I didn't make earlier is that this does not preempt or foreclose the other avenues that are currently available for service members or spouses. If they choose to obtain a license in California, they're still entitled to the expedited application process, and the departments, all the licensing entities in the department are currently implementing the AB 107 temporary license provision. So a service member or spouse could avail themselves of those opportunities as well.
Are there some states who just were not allowing these certain individuals that we're talking about to come and practice sooner? Is that why this is all happening? Because, I mean, it seems like we're behind the 8 ball here with our board. Or there's some boards and bureaus in our state that weren't there yet?
I think the diplomatic answer to that is yes, that there are other points of resistance, not necessarily this board or this state or anything like that, but the Department of Defense has had this kind of continuing issue with licensure portability, deployments, reassignments, those kind of things, and the lack of flexibility for not only their active duty members, but their military spouses. And so I think, for about 10 years now, they've been attempting to employ, and in collaboration with those states, new ideas such as move to the front of the line, expedites. We've taken that one step further and devoted a liaison, a resource too, so that we can help them walk through the process, make it easier. We want their transition coming to California to be just about as simple as it possibly can be. That may not be in other areas of California or other states for that matter, and so this federal statute is kind of just a blanket solution to everything, an end-all be-all, if you will.
And you said that the number of people we get who are going to fit under this blanket is pretty small.
Yeah, even when you think about even the military expedites that we already have had for the last few years, you're usually looking at double-digit numbers per year.
Yeah.
So in light of the normal licensing population, the applications received every year, this is a smaller load. It's a smaller load, but each individual application is a little bit more complex in the situation, how much analysis needs to be provided to the application, how many resources, because we're trying to get all their ducks in a row and get them in as quickly as we possibly can. One of the other points that Michael made is that this mostly pertains to the military spouse, right? The active duty member who has been stationed in a California base, who may be serving in the military as a physical therapist, usually has some kind of prohibition in their own orders that they can't practice in any other capacity but their military service. So we're not going to see too many of those. it's really the spouses that we're going to be seeing that are traveling, with their significant others.
And you mentioned that if they were licensed in another state but didn't pay their fees and their license was inactive, we weren't going to necessarily not allow them to practice here?
Yeah, so the idea of license in good standing, one, it's going to, and that's a California definition, by the way, right? So when we're saying, we say license in good standing is essentially anything other than discipline, right? So if it, like to Michael's credit, inactive, or an inactive in other states could be no fees paid, right? In California, you just happen to pay a fee to be inactive, but retired, reduced fee, prohibitions of practice, those kind of things. They're not disciplinary driven, right? They're not meant that that person had an issue, that potential military spouse or military service member had an issue in that state that pertains to the way they practice. They may just be abandoning that state and moving on to the next state kind of thing. So we wouldn't hold those states against them. We would look into each one and we would try to discern, why they were delinquent or why they were inactive, or any number of other definitions that other states might use, and try to figure out what category they fit in. If they had discipline in another state, they would be conclusively presumed to not fall under this authority. They'd be disqualified.
But they will,
They could always apply for our other avenues for military members.
but as Mr. Kaiser pointed out earlier, they would have to have one license that's active and good standing, and that would be the license that they are practicing under while in California under military orders. So if someone is licensed in New Jersey, Texas, and Florida, and their New Jersey license is the one that they've used in the past 2 years that's active, they'd be practicing under the New Jersey license, and the Florida and Texas license could be in any other status other than under some disciplinary order, revoked, on probation. I mean, if it's prior discipline and their license has returned to good standing in that state, that's not going to count either. So.
Okay. And what kind of documentation might the board ask for from maybe a military spouse as far as their work experience
So that's
in the last 2 years?
Yeah, that's an interesting debate that we've had at the department-wide level as a result of just becoming aware of this federal statute is active within the last 2 years is any number of shades of gray, right? It could be saw one patient in the last 2 years, and we would give them the benefit of that doubt. That would allow them to qualify here.
That's a really good question, and I think the statute requires them to sign basically an affidavit saying that they've performed some activity in the last 2 years.
I had a question.
Notarized affidavit? Guess it wouldn't really matter.
I don't think so. Let me.
I don't believe it would be notarized. At most, it may be under penalty of perjury.
I'm just wondering, I know these are very small numbers, but does it require that we create another category in our current licensure assessment, or are we calling these people registrants? Is there going to have to be, you mentioned that there's going to be, even though it's small numbers, there's layers to the assessment of the candidate, right? And some other extraneous requirements that, including like looking at the term or the tour dates and then maintaining those records and being prepared to send them a notice that they're like 6 months out or 3 months out from the date that they had provided.
It's a very good question. By the nature of SB 143 and the creation of this kind of online repository, or at least the intent to create an online repository, the onus of practice, in your point about the actual military order and its termination date, the onus of that falls on the military member, right? And so we wouldn't be active in sending reminders saying that you're coming up on the end of your military order. And even converse to that would be if that military member received an extension, they would have been obligated to send that extension to us as well so that we could extend that date. But almost everything in regards to this federal statute that this board will be interacting with these military members or their spouses will be reactionary, right? It will be what we would say is mostly on the enforcement side of things, right? So there wouldn't be any notices of reminders. There won't be, the whole idea is to try and remove the application difficulties for these military members to come practice in California while they are active duty on an order. And so if we built too much of a application process, we've kind of taken the wind out of the sails of the federal statute. So
I have a question about continuing education requirements. Does the clock or the date start when they start practicing here, or do we go back 2 years, or like for us, 7 years?
That's an interesting question, and it's unclear.
yeah. Internally, I can tell you that an example of where we might look at the continuing competency regulations as they pertain to a military member would be if we had received a consumer complaint about that military member. And as part of that investigation, one of the things that we would ask them was, have you, in California, for however long you've been here, have you collected 30 hours within the last 2 years? Because they don't have a renewal period to rely on, like a typical licensee, right? So we can't audit them in a sense of trying to nail down, you needed 30 hours within this renewal period. But we can look at the other side or the other spirit of that particular statute, and that is that aside from the 2-year renewal, if they were to go from inactive to active, the question we would ask them is, have you collected 30 hours within the last 2 years? And so in an investigation pertaining to something completely different than continuing competency, we might look at that. And it might be very relevant, right? It might be a violation that really has to do more with the differences in practice acts from where they were licensed to here in California. And a good example of that might just be the supervision level of assistance, right? In the state that they came from, it may not, no spoken rule. And then here in California, the restriction to 2. And they weren't aware of it. Well, in that case, continuing competency becomes very relevant. And we would say, have you taken 2 hours in laws and ethics as they pertain to the practice of PT in California? And if they haven't, they are still subject to that authority.
Now, it may also be interpreted, and again, I'm not sure, we just have been looking at this language over the past week or so. But another way to interpret the continuing competency requirement is to treat them like they're a new licensee, and as if they just received their California license, and so within the period that they're here, presuming they're here for 2 years, they would need to do the continuing competency just as a new licensee would.
That's a good point. The concept of the registrant could be seen as kind of the new 2-year renewal period for that person. And again, dependent upon whether their orders actually kept them here for that full duration of time. From the administrator's perspective, I don't know that would be a useful use of our resources and really kind of maintaining and focusing and in a way singling out those military members and auditing them at a higher rate than I even audit my own licensing population for that matter.
Just as a side, I'm trying to understand if I was an employer of physical therapists and I got an application for someone like this, what would they be providing me for me to know that they're authorized to practice physical therapy in this state?
Also a very good question, because it's a whole new world, right? And so we're trying to envision a number of different aspects. One of them is employment and how employers or third-party payers could even verify their ability to practice. The federal statute doesn't really speak to the state's obligation to provide proof of that, but we want to, right? For our own consumers and the sake of clarity of authority and who can practice and who can't, we want to help provide that. And so we are working on correspondence that, especially after the registration system gets set up, once we do that very basic vetting to see if they've met the requirements of the federal statute and the trailer bill language that was just passed, that they would receive correspondence that essentially says, and we agree that you may qualify to practice under this authority. And that letter could be used to provide to the employer, theoretically. The other part is the website portal that the military member could ask the employer to use to verify. And they would see it, and the way I understand it, there may be a different portal than the DCA search portal. But if it is the DCA search portal, that's even better. Just a plug for the DCA people in the room. One central, location for any California consumer to go and verify just the search of a name. But the response back would be, John Smith, and has different client text, a different description. This person may be here practicing under a federal authority, so that the consumer knows that, so that the employer knows that, and the insurance companies know that as well.
My employer requires an end date on my certification of licensure. How does this work for that person? Because that's kind of where I was going with the previous question. If we're
Yeah.
not maintaining that number, or it's not, is it going to be maybe in that registrant database? Because at some point, if I was employing a spouse of a military personnel and their term,
Yeah.
their tour was over, but they were still seeing my patients,
You want to schedule for, and you want to avoid, them practicing unlicensed. I get it.
and I understand you said that we are not going to be enforcing or monitoring that. That's their responsibility. But then I'm a stakeholder as an employer of physical therapists, and I'm just trying to understand if,
Well,
The portal itself is still being designed, and so depending on the assignment order received, there may be a field in the portal where we might be able to display. So as far as we know, based on the military order we've received, that they are authorized to practice under the federal statute up to this date. And then again, if there's an extension, they're obligated to send it to us so we could update it. But I'll keep that in mind to make sure that we try to cover that.
Good question.
Yeah, one of the requirements for posting on the internet website is the person's registration status. So that may be the opportunity for us to, if we can ascertain what their end date is, to post that. I'm not sure how that's going to be interpreted at this point. But the other general comment, because it's a very apt question in terms of employers needing verification, perhaps insurance companies, and there are probably other situations where someone's going to want to have some verification that they're permitted to practice under the federal law authority. And, just thinking out loud here, we think that's going to be a good incentive for people to register and use the registration process. And it's helpful for the board, it's helpful for the public, and it's helpful for the service member or spouse that's practicing.
I really would appreciate, I think, the concept of having the end date versus a current or not current, because if it was one day it could be current and then the next day it says non-current, but
Right.
I've got patients scheduled and they,
There's there is a reality that could happen though, right? So military orders commonly have an end date, an assignment, but they also have, it's also very common to see it to be determined, right? So you're going there, but we're not quite sure how long you're going to stay there yet, and so we'll have to take that in consideration when we're looking at how it's displayed through the portal.
And they could change as well.
Right.
So it really is incumbent on the service member or spouse to only practice when they are residing in the state under that order. The other situation that we've discussed is if the spouse and the service member are divorced or they dissolve their domestic partnership, the privilege to practice for the spouse would immediately end. Yeah.
Are they, any of the licensee, including this case, are they required to have a live scan every year or
No.
No.
no?
No.
And I can't speak for Congress, but I presume that the reason for that is that Congress is presuming that the licensing state that is the current license that they're practicing under in California has done that.
So, for my members and their knowledge, it's a very intricate conversation when you take into consideration things like licensure compact and portability and reciprocity amongst states. This is essentially kind of a trump card that has been issued by the federal government for military and military spouses. So, similar to some of the concerns that we have about consumer protection as it pertains to the licensure compact, which comes down to like background checks. This is an issue here too. I think the volume is small enough that it kind of negates the concern itself. There are some other kind of stopgap measures in place too with military service. If those folks do have any kind of criminal issues or criminal history, there's a whole different judicial system within the military that handles that. And so we may not even be presented with any of those kind of issues because they're already filtered out. Military spouse is probably the only concern that we have at that point. And even to the conversation that Michael kind of mentioned about military spouse and is the authority rooted in that marriage certificate and those kind of things, all of those are, it might take us a very long time to experience any of those situations, kind of 1 in a million odds that these things are happening, especially when we're talking about double-digit, numbers per year of seeing these folks. So even to Dr. Brandon's point, running across somebody for the employment issue, it might take you a couple years before you get to that. I think the closer you are to whatever the military bases they're assigned, the higher the possibility you might run into them.
But just to answer your question, also to add on, Mr. Q, when a PT applies to a hospital or a clinic or a company, they typically do a background check, which includes fingerprints. So there's a little safety
At the
net there.
employment level.
Yeah, at the employment level.
I have a similar question to Mr. Q, and that's the Cal Law exam. So does this individual coming in under SB 143 take the Cal Law exam?
No.
How can that be?
Because federal
Simply-
law preempts it.
So they're practicing here without really, well, we don't know, but I mean, we don't have that check.
So I think, simply put, I would say federal law trumps state law. Having said that, the way that the federal statute is written, it says submit to the authority when it, in regards to things like continuing competency, and puts the onus back on the practitioner of practicing within the scope for California. The federal expectation of its own service members and military spouses is they do that homework before they come, right? So while we don't have anything pre-application process, pre-registration process, or whatever we'd like to call it, no precautions set in place, there is an expectation that they're supposed to do that before they come, and they could be subject to discipline as a result of, that's why I said it's almost on the back end. Everything is on the enforcement side of where we can enforce it.
Any further questions?
Maybe, oh, there's,
Am I opening to public?
Go public comment. Yes.
Public
Yeah,
com-
absolutely.
Mr. K. Yeah.
Yeah.
Good morning.
Good morning. Mitch Kay, I represent CPTA and also my employer. As an employee, our company has to credential all of our therapists, and there are 7,000 in California that we credential, and we have contracts with insurance companies to do that credentialing. And I'm just warning the board that you're going to be inundated with calls as to when we do the credentialing, we have to have a licensed person for California to be credentialed by a payer. And they scrutinize that closely, and we have to be ready to meet the demand of that. Even though, like for citations and actions against a licensee, the board says in their documentation that this should not be used against the licensee. That's not true. There are many offices that have had to let go therapists that are on probation because the insurance company will deny them credentialing, the whole practice credentialing, not just that one therapist. So I caution you on that.
Yeah, we're aware, and if there were anything we could do other than the situation that we're in now,
Right.
we might have done it differently. But again, the federal statute is not something that we have any control over.
I'm just preparing
Yeah.
you. I'm not
Oh,
trying
yeah.
to be a naysayer. I'm just
Yeah.
preparing you that there are going to be a lot of questions coming through in that regard. And also, the first slide that you had on says effective 1/5/23. Isn't it 24?
No, it's 23.
It was effective in January.
Oh,
Yeah.
thank you.
I know you only had a few slides, but if you don't mind going through them again, I know I had some questions as you were going through. It might spark my memory.
Certainly.
You've covered quite a bit, though. Okay, not this slide. Yep, not this slide. We got there. I think it was that 2-year period question. And that's something, they sign an affidavit, you said.
Yeah, so SB 143 requires them to sign an affidavit, doesn't require it to be notarized, but requires them to sign an affidavit indicating that they meet all of those requirements, including the practice within the last, well, actively using the license within the last 2 years.
Okay. And the next.
And it would have to be the license that is active. If they have licenses in multiple states, it would have to be that license that's active that they're going to be practicing under in California or in other state that they're required to reside in for their military orders.
That makes sense.
Yeah.
Okay, thank you. And then, I don't know if there's another slide, but. Yep, nothing there. I think we got it, thank you. Yep,
You know, just to reinforce the second point here, they're subject to the same standards and requirements as a California licensee, even in terms of standards of practice or the standard of care is what I was going for in terms of professional negligence. They would be required to meet the standard of care for a California licensee as opposed to whatever the standards may be in the state where their license is from. That's it. Thanks, everyone.
Any further board comment or public comment? Hearing none. Thank you, Michael. Okay, moving on. To item number 16, our legislation report. Hi, Brooke.
Good morning. So the legislation report begins on page 49 of the meeting materials. We are approaching the end of the first year of this legislative session and are watching over 45 bills thus far. We did see a 29% increase in bills introduced this year from both the Senate and Assembly in comparison to last year. This year, the Assembly introduced 1,970 bills, and the Senate introduced 1,054 bills for a total of 3,024 bills. September 1st was the big appropriations deadline, which required all bills leave their fiscal committees and reach the floor. Most bills which failed to reach the floor and remained in appropriations after this deadline became 2-year bills, and they can be potentially acted upon January of 2024. There was a total of 196 bills that failed the appropriations deadline this year in comparison to 115 that failed last year and only 31 in 2019. So that is a significant increase as well. Currently, all bills moving forward are either on the floor and engrossing and enrolling or on the governor's desk. September 8th was the last day to amend bills on the floor, and today, September 14th, is the last day for each house to pass bills, and the governor has until October 14th to sign or veto bills, and all statutes will take effect on January 1st, 2024. For the legislative summary, before I go into each bill specifically, we did group them into two categories, either physical therapy board legislation, which are bills that could potentially impact the PTBC, PT practice, regulations, or the operations of the PTBC. The second category is department-wide legislation, which are bills that could potentially have a department-wide impact or more of an administrative impact on the PTBC.
Thank you for doing that.
Of course. First bill is AB 47, pelvic floor physical therapy coverage. This bill was introduced on 12/5/2023. This bill would require a healthcare service plan contract or health insurance policy issued, amended, or renewed on or after January 1st, 2024 to provide coverage for pelvic floor physical therapy after pregnancy. This bill's last location was the Assembly Health Committee, and since it failed the legislative deadline, it is now a 2-year bill and may be acted upon January of 2024 in the second year of this legislative session. At the March board meeting, the board did take a support position on AB 47, and a copy of that support letter was included in the board meeting materials, and that was disseminated to both the legislature and the author's office. The second bill is AB 381, Teacher Credentialing Services Credential with a specialization in health, occupational, and physical therapists, and this bill was amended on May 1st, 2023. This bill would allow occupational therapists and PTs to use their specializations to hold teacher credentials and with a specialization in health. This bill's last location was the Assembly Appropriation Suspense File, and since it failed the legislative deadline, it is now a 2-year bill as well and may be acted upon January 2024. At the March board meeting, the board also took a support position on AB 381, and a copy of that letter was also included and submitted to the legislature earlier in the session. The next bill is AB 796, Athletic Trainers, and that bill was amended on July 6th, and its last location was the Senate B&P Committee. And since it failed the legislative deadline, it is now a 2-year bill and may be acted upon January 2024. This bill would enact the Athletic Training Practice Act, which would establish until January 1st, 2028, the Athletic Trainer Registration Committee within the Medical Board of California to register athletic trainers and administer duties under the Act. The bill would prohibit a person from practicing as an athletic trainer or using certain titles or terms without being registered by that committee. Okay, moving on to AB 814, Veterinary Medicine, Animal Physical Rehabilitation. This bill was amended on April 27th, 2023. The Veterinary Medicine Practice Act provides for the licensure and regulation of veterinarians and the practice of veterinary medicine by the Veterinary Medical Board, which is within the DCA. That act makes it unlawful for any person to practice veterinary medicine in the state without a license, and provides that the practice of veterinary medicine includes, among other things, the treatment of whatever nature for the prevention, cure, or relief of a wound, fracture, bodily injury, or disease of an animal. This bill would state that the intent of the legislature to enact subsequent legislation to authorize a veterinarian to refer an animal to a licensed PT holding an advanced certification to provide animal physical rehabilitation under the supervision of the veterinarian. This bill is now a 2-year bill, as it did not pass out of the Senate B&P Committee by the legislative deadline and could be acted upon again January 2024. Additionally, in front of you, we have included a handout. It's a letter that we received on behalf of the Animal Physical Therapy Coalition regarding their support of AB 814. And the next bill on the legislative summary is AB 820, State Boards and Commissions, Seniors. This bill was amended on July 3rd and was held under submission in the Senate Appropriations Committee. This bill would require the composition of various advisory groups and bodies to include a state agency official responsible for administering programs that serve, or state commission official that advocates on behalf of older adults as defined, or a representative from an organization that serves or advocates on behalf of older adults. For purposes of this bill, older adult is defined as a person 60 years of age or older. The next bill is AB 931.
Sorry,
prior-
Brooke,
oh, yeah, of
where's
course.
this bill at right
What-
now? 820?
Oh, this one, it's a 2-year bill.
It's,
Yes. It was held under submission in the Senate Appropriations Committee. Okay, and AB 931, prior authorization physical therapy. On September 11th, the Assembly concurred with the Senate's amendments, and on 9/12, the bill was enrolled. This bill would prohibit a health care service plan contract or health insurance policy issued, amended, or renewed on or after January 1st, 2025, that provides coverage for physical therapy from imposing prior authorization for the initial 12 treatment visits for new episodes of care for PT. Additionally, this bill would require a physical therapy provider to verify an enrollee's or an insurance coverage and disclose their share of the cost of care as specified in the bill. This bill additionally would require a physical therapy provider to obtain separate written consent for costs that may not be covered by the enrollee's or insurance plan, contract, or policy that includes a written estimate of the cost of care for which the enrollee or insured is responsible if coverage is denied or otherwise not applicable. With respect for health care service plans, this bill would specify that its provisions do not apply to Medi-Cal managed care plan contracts. The board did take a support position on this bill at the March 2023 meeting, and a copy of that letter is on, I believe, page 64 of the meeting materials. And again, this letter was sent to both the author's office and the legislature. And the next bill is the popular SB 143, state government, that we just covered during Michael's presentation. And it was signed by the governor and chaptered yesterday, the 13th of September. And because it is a trailer bill, it did become effective immediately rather than January 1st, 2024.
Did you take that one in the sequence?
I don't think so, because they're grouped in
Okay.
the two separate. Yeah, we'll go
Got
back
it.
to the other. And again, let's see. So, and as Mr. Knotes covered in great detail earlier in his presentation, this bill would require a registering authority defined as specified boards, bureaus, and commissions, and the Department of Real Estate to register a service member or a spouse of a service member who relocated to the state because of military orders for military service within the state and meets specified requirements, including that the applicant submits to the registering authority an affidavit attesting that the applicant meets all of these requirements, and the information submitted to the registering authority is accurate to the best of the applicant's knowledge. This bill additionally would require the registering authority to post specified information on the registering authority's internet website for each person registered pursuant to the provisions of the bill. This bill additionally would provide that a person registered pursuant to these provisions be deemed to be a licensee of the registering authority for purposes of the laws administered by that registering authority relating to the standards of practice, discipline, and continuing education as specified, and would authorize the registering authority to take specified enforcement actions against that person. Additionally, this bill would prohibit a registering authority from collecting or requiring a fee for registration pursuant to the provisions of the bill. Okay, the next bill on the legislative summary is SB 544, the Badgley-Keene Open Meetings Act teleconferencing. This bill was amended in the Assembly on the 8th of September, and on the 13th it was read a third time and passed, and then ordered to the Senate. It is currently in the Senate with concurrence in the Assembly amendments pending. So this bill is sponsored by the California Commission on Aging, and it revises until January 1st, 2026, certain teleconference requirements under the Badgley-Keene Open Meeting Act, which requires all meetings of a state body be open and public. I'll go over specifically some of the provisions as outlined in the bill. So it preserves the Badgley-Keene Open Meeting Act as is with no changes. Members can attend meetings from multiple different teleconference sites connected electronically via audio and video, and the public must be allowed to personally attend each teleconference site where a member is located. For purposes of this bill, a teleconference location is defined to mean a physical location that is accessible to the public and from which members of the public may participate in the meeting. Additionally, this bill adds a new but not exclusive teleconference option, which is specified in Government Code Section 11123.2 that requires a majority of the members of the state body They must be physically present and accessible at a location, and it also allows additional members above a majority to participate in the meeting from non-public sites, defined as remote sites, as long as the public can also participate in the meeting both remotely and from publicly accessed sites. So a remote location is not required to be accessible to the public. The notice and agenda shall not disclose information regarding a remote location. If a member of the state body attends the meeting by teleconference from a remote location, the member shall disclose whether any individuals 18 years of age or older are present in the room at the remote location with the member and the general nature of the member's relationship with those individuals. In addition, the members of the state body shall visibly appear on camera during the open portion of a meeting that is publicly accessible via the internet or other online platform. This bill also requires that upon discovering that a means of remote public access and participation required has failed during a meeting and cannot be restored, that the state body shall end or adjourn the meeting. This bill would also permit a person to submit anonymous information when using the internet website or other online platform to attend the meeting via an exemption, where some internet websites require you to log in with your name, your email address. So this would exclude that as being a requirement to join the meeting. And additionally, this bill amends existing law, Government Code Section 11123.5 for advisory bodies only, to allow all members of advisory bodies to participate remotely in meetings from private, non-public locations, as long as there's one physical location with at least one staff member where the public can attend. And the public can also attend remotely. I know that's a lot of information. PTBC's board president, Ms. McMillian, took an interim support position on this bill in July, since the June board meeting unfortunately was canceled. And a copy of that interim support letter is included on the meeting materials on page 66, which was submitted to the legislature. Staff are recommending that the board consider taking an official position of support on this bill, as it will increase public access and engagement from our stakeholders.
Something beyond what Ms. McMillian already did?
It kind of a two-step process, or at least potentially a two-step process. We do need a motion to accept President McMillian's interim position by the board, and then maybe a conversation post that. I don't know, it's late enough in the session now that a letter of support for 544 is not necessarily needed at that point, but we do need to ratify the existing interim position.
Even though it was already sent?
Yes, the board president can send an interim position on behalf of the board, but that position does need to be ratified at the next board meeting by the composure of the members.
At this time,
Yes, well,
should we,
relatively soon.
I mean, could we make a motion?
Absolutely.
Okay. I move to support President McMillian's letter on SB 544.
I second.
Any other comment? Take public comment? So can we take a roll call vote, please?
Tanya McMillian,
Aye.
Dale Armstrong,
Aye.
Karen Brandon,
Aye.
Katarina Elevi,
Aye.
Samuel Pugh,
Aye.
Alicia Bena Amen.
Aye.
6-0, motion carried. Thank
So
you.
now that 544 is about as clear as mud, I think there is some kind of conversation just to be had so we can understand kind of like the practical application of it, should it be signed by the governor. And there's two things to consider. SB 143, the trailer bill that we talked about that has language pertaining to the federal statute for military spouses, also has language in it that essentially extended the executive order during the pandemic for teleconferences until January 1st of this upcoming year. So for the rest of the year, we can do remote meetings similar to that of which we did during the pandemic. After January 1st, if 544 is adopted, we have this kind of weird, nuanced, layered process. Bagley Keene in its entirety remains the same, meaning that you still could have what we call old-fashioned teleconferences, where we would do it via telephone, and each member would have to publicly post where they are and make that location accessible to the public. And then an additional amendment to that, or in addition to that statute, that allows for kind of an in-between, where we could do a remote meeting, but a majority of the board members would have to be in a single location. Meaning, like if we were meeting in Sacramento, I'd have to have, 4 of you there. The other 3 could participate remotely. Those 3 that were participating remotely would not have to post where they were, would not have to make it publicly accessible. But I would have to be able to provide access to the public so that the public could participate remotely and come to our physical location where we had the majority of you as members. Kind of okay, but if you're going to do that, we want it to be a little bit more strenuous than just what happened during the pandemic.
And even a further nuance, if a board member has a disability and is unable to come to the physical location, they can, prior to the meeting, obtain, presuming this becomes law, they can obtain an exemption, and then they would not count towards the majority being present. So if one of our members were in that situation, then we would only need to have 3 members present in the room rather than 4.
And when Brooke was reading the information, I was trying to understand it. It sounded like you could have more than one teleconferencing spot, no?
If you go with the traditional teleconference, you could have up to 7, right? Because it's 7 different, well, actually, I would say 8. You could have the central location where staff, and then each board member theoretically could be at a different location somewhere within California that's accessible to California citizens.
That was the pre-pandemic model.
That's the old model, right? And that's still there. It's
Yeah.
still an option. And then that second edition is, or if you're going to use the virtual model, you have to have one physical location where the public can participate. And in that location, a majority of the members, but to Michael's credit, you could have exemptions for things like illness or disability. But the other members could participate remotely
Yes.
from the comfort of their own home, as an
Yeah.
example, and not have to display that address information or provide access to the public at that location.
Yeah, I understood that. I think I thought when she was reading it that you could actually maybe even have 2 teleconferencing sites, not the remote sites.
Yes, you can.
Yeah, so like,
Yeah,
I don't
you
know,
could.
3 members in Sacramento and 3 members in LA altogether.
So that would be using the traditional teleconferencing rules, and so some of my other clients have utilized sort of a procedure like that, where all the members from Southern California come together in a location. Because the real danger of the traditional teleconference, if you have several locations, if any one of those locations goes down, then you have to cancel the meeting. You have to stop the meeting, adjourn the meeting until it comes back up.
We don't want that.
Did I hear you correctly so if you're attending the meeting remotely, did you say that each party has to be present on the
camera.
screen? So does that mean we need to see their faces, or can folks put up the pictures? Like,
I think the intent is that we actually see you, body language and all.
okay.
Yeah.
And to add an additional layer of complexity, in California, we love to enact really complex statutory schemes. If the ability to view all of the members is impeded by internet connection or some other technical problem, there's an exception for that.
Just for the video portion. If it hinders the participation of audio of either the members or the ability for the public to participate, then you'd have to call the meeting a quit.
Because we've had that happen before, right? Like, okay.
The other interesting aspect is that advisory committees can have a full virtual meeting the way we did in the pandemic for board meetings. So it may encourage some boards to shift some of their business to advisory committees and utilize that provision, but, you know, that remains to be seen.
Repeat that, Michael. So, to shift to advisory committees, what do you mean?
Well, some boards have standing committees, like they'll have a legislation committee, an enforcement committee, a regulatory committee. And rather than doing a lot of that business in those discussions in the main board meeting, they will make decisions and then advise the board. So we discussed this bill in committee, we recommend this, and it can, it can streamline the board meeting to an extent.
Any public comment? Hearing none, so.
Okay, I'll
move on.
continue. So now we're moving on to the department-wide legislation. AB 996, DCA Continuing Education Conflict of Interest Policy, was ordered to inactive file at the request of Senator Roth on August 17th. This bill would require entities within DCA who are responsible for approving continuing education providers or courses to develop and maintain a conflict of interest policy that discourages the use of any continuing education course if the provider of that course has an economic interest in a commercial product or enterprise promoted in that course, and requires conflicts to be disclosed at the beginning of each continuing education course.
And where's that at? I'm sorry.
That one is on inactive file at the request
Inactive.
of Senator Roth. AB 1028, Reporting of Crimes, Mandated Reporters, was amended in the Senate on June 28th, and that bill failed the legislative deadline on the 1st of September, and the last location of that bill was the Senate Approps file on the 29th, and it may be acted upon, again, January 2024. AB 1163, Lesbian, Gay, Bisexual, and Transgender Disparities Reduction Act, was amended in the Senate on September 8th and was signed by the governor and chaptered yesterday, September 13th. This bill expands the data collection requirements in the Lesbian, Gay, Bisexual, and Transgender Disparities Reduction Act to additionally apply to the Department of State Hospitals, the Department of Rehabilitation, the Department of Developmental Services, and the Department of Community Services and Development. The most recent amendments on this bill that were concurred in amended the compliance dates by an increase of 1 year for the provisions of the bill. The next bill, AB 1751, opioid prescriptions, information, non-pharmacological treatments for pain, was amended on April 13th in the Assembly, and its last location was the Assembly Health Committee. However, it did fail the legislative deadline and is now a 2-year bill. SB 14, Serious Felonies, Human Trafficking, was amended on the 1st of September and was passed out of the Assembly. And on the 13th, yesterday, the Senate concurred with the Assembly amendments, and it was ordered to engrossing and enrolling. This bill designates human trafficking of a minor for purposes of a commercial sex act as a serious felony, making it a strike for the purposes of the 3 strikes law. SB 268, Crimes, Serious and Violent Felonies, was amended in the Senate on April 25th. However, it failed the legislative deadline, and its last location was the Senate Public Safety Committee and is now a 2-year bill. SB 372, DCA Licensee and Registrant Records Name and Gender Changes, was amended in the Assembly on the 1st of September, and it was enrolled and presented to the governor on the 11th of September. This bill would require a board within DCA to update a licensee's or registrant's license by replacing references to the former name or gender of the license or registration as specified in the bill. If the board receives documentation from the licensee or registrant demonstrating that the licensee or registrant's legal name or gender has been changed. If the board operates an online license verification system, this bill would require the board to replace references to the licensee's or registrant's former name or gender with the individual's current name or gender as applicable on the publicly viewable information displayed on the internet. SB 525, minimum wage healthcare workers, was amended in the Assembly on the 11th of September, and on the 13th, yesterday, it was read a second time and ordered to a third reading. With its most recent amendments, this bill would establish separate minimum wage schedules for covered healthcare employees, as defined within the provisions of the bill, depending on the nature of the employer. This includes the following. Dialysis clinics and large healthcare systems with more than 10,000 workers would pay a minimum wage of $23 an hour in 2024, $24 in 2025, and $25 in 2026. Hospitals with a high mix of Medi-Cal and Medicare patients, as well as rural independent hospitals, would have to pay workers $18 an hour in 2024. That rate would increase 3.5% annually until it reaches 25 in 2033. Community clinics would start the pay increase at $21 per hour in 2024, rising to $22 in 2026 and $25 in 2027. So it's an incremental pay increase over the years.
Brooke,
Yes.
can you elaborate a little bit more, depending on the nature of the employer? What?
So it's basically on the number of employees.
Okay.
Yes. So, for example, the first one, the dialysis clinics and large healthcare systems, those are defined as 10,000 workers or less. Any further questions on that, on 525? SB 816, Professions of Vacations. This is the BMP Omnibus Bill. This bill was amended in the Assembly on the 8th of September, and on the 13th, the Senate concurred with the Assembly amendments. This bill raises several types of licensing fees imposed by the Board of Psychology, Board of Pharmacy, Board of Accountancy, and the Landscape Architects Technical Committee. Additionally, it makes additional clarifying changes pertaining to some other boards in DCA. And that is the last bill on the legislative summary. Did the board have any additional questions that I could answer?
Thank you for your work.
Any public comment? Okay, I'm hearing none. Thank you, Brooke. We're gonna keep it with you, Brooke. Moving on to item number 17, rulemaking report.
Okay. So for the rulemaking report, I am very happy to report that the performance evaluation tool for foreign educated PTs was submitted to OAL, the Office of Administrative Law, on March 28th, and it was approved and became effective on May 9th, 2023. And so we are very, very thrilled about that. We have the final rulemaking file is posted on the board's website. The other item on the rulemaking report is the continuing competency regulations, and we are still in the process of researching and developing regulatory proposals for those, and we'll be presenting those for the board at a possible meeting date in the future.
Brooke, excuse me, so you said the rulemaking, the update will be posted on the new and improved website?
Yes, we are required to post the final rulemaking package on the board's website.
Can you tell me what category that would fall under on the new website, the new awesome website?
Yes, that's under the Laws and Regulations tab. So you'll hit Laws and Regulations Home, and then on the sidebar navigational screen, you'll hit newly adopted regulations.
Thank you.
And then I might add, in that same navigation screen, we have a tab that says Proposed Regulations, of which now is empty. All of those regulations that we have been working on are off the slate. They are now in law. So
we're awesome, just like the new awesome website.
yeah, and I alluded to it yesterday about the theme since the cancellation of the June meeting has just been busy. I mean, Brooke kind of touched on it a little bit. The legislative session itself has been kind of record-breaking with the number of bills and the activity. Even just the kind of chaotic calendaring of hearings and schedules for each of these bills. We've had hurricanes that have, along the Southern California coast that have kind of delayed things. And so they are really in a mad rush right now. And Brooke has been, we've spent a lot of time watching hearings to try and keep track of everything as it's moving. And then with regulations also, right? Just having that, at the last March meeting, we were telling you that that regulation would be going into effect. It went into effect in May. We couldn't share you with that in June with the cancellation, but now here we are a few months later. So that's been up and running and off of our tablet for quite a while. Now we can kind of look at investing resources into perusing and reviewing and trying to figure out how to better polish the continuing competency regulations.
I just want to thank the regulations unit and our staff too for getting that PET through, because obviously I appreciate the dates that are listed here on this regulation, and we were in a holding pattern for quite a while.
Yeah.
And so since 2022, it looks like things have moved on, steadily. So thank you, and thank you to the reg unit as well.
Yes, thank you. I'm just going to point out one additional thing. At the December meeting upcoming, we'll be presenting the 2024 proposed rulemaking calendar for board consideration, and that just helps map out for the Office of Administrative Law our proposed rulemaking for the continued year. And that concludes my report.
Sorry, she heard me inhale like I was going to say something. Continuing competency language, when is that coming?
I would say best guess is probably by the March meeting. We have ideas of proposals that we'd like to present to you. I think we just need a little bit more work. And again, we kind of touched on vacancy issues, and the continuing competency unit is, half-staffed at this point. So our experts are busy auditing licensees and looking at recognized approval agencies, and in their spare time we're looking at what we might propose as regulatory change.
Thank you. And then just a comment on the reg that we did get to go through. I know that way back when there was a very spirited conversation about that reg and including the two different evaluation tools. And so I guess I have a couple of things about that. One is I'm curious if the board staff might be able to report back at a future meeting on the use of one or the other.
Okay.
And also just wanted to bring up that the CPI was again updated to a new version. So
Yeah.
I don't know, just throwing that out there.
Yeah, I think we can incorporate that into the applications and licensing report in December, and just, show you the statistics of, through our clinical instructors who are using the PET and who are still using the so antiquated paper CPI from 1997. So.
Any further comments? Any public comment? Oh.
I have a question.
Can you push there you go.
I have a question regarding potential regulations related to SB 372, registrant name changes. I'm curious, does the board think that there will need to be regulations to implement that, given that I understand names might need to be changed in the system, but if someone has a disciplinary record or has some kind of record going back, will those documents also have to be changed to reflect the person's new name that they identify with?
Currently, the way the statute is written, if we receive a request to have those documents changed, they have to be specific in which documents they would like to be changed. And so in the situation where there might be a disciplinary history, that would have to be part of the request. But if it was requested, we would have to go back and change those names for that.
Do you anticipate having to have regulations to reflect that this document was changed? Just from a consumer perspective, you would want to know that, somebody I dealt with in the past may be going by a different name.
Sure. There's a similar a scheme set in place right now for licensees to be able to protect, if you will, previous history, and it's usually based on a court order of some kind, and we would need that in this instance too. So like in the example of a gender change, it wouldn't be just a simple gender change that somebody decides. They'd have to go through a court system outside of this administrative process and provide us with that legal documentation. What you typically see is if you were to go to try and verify that name on the website, the name would be there, the history would be there, but the documents would not be attached. There would be a link for you as a requester to make a request to the board directly for us to provide those to you. And those would have kind of a combination of the historical document and the redacted documents with it. So I don't think that there's going to necessarily be any promulgation of regulation needed. The statute alone is fairly substantial.
Thank you.
No problem.
Can you state your name?
My name is Kenneth Armstrong.
Hi, are you a student here?
I'm not a student here.
Okay, but thank you. That was a really good question.
It is.
Thank you. Thank you. Any further public comment? Okay, well, we will move on to item number 18, our communication and education updates. Hi, April.
Good morning. My name is April Beauchamp, and I am the Communication and Education Liaison for the Physical Therapy Board of California, and I will be presenting the outreach report. For the website, during fiscal year 2022-23, quarter 4, the PTBC had 138,067 web hits through its website page tabs. This resulted in a 0.35% decrease from last fiscal year, quarter 4. And for the end of the year, the PTBC had 549,348 web hits through its website tabs, which resulted in an overall 2% decrease from last fiscal year. For social media, so for Facebook, we received 20 likes, resulting in a decrease of 64% for page likes compared to last fiscal year, quarter 4. In comparison to last fiscal year, quarter 4, there was also an increase of 149% in page visits, and then a decrease of 10% of page reach, which is the number of people who saw any content from our Facebook page. Year to date, the PTBC had 6,802 page reach impressions, 3,965 page visits, and 161 new followers. This fiscal year, quarter 4, we had a 33% increase in page reach for Instagram and a 69% increase in profile visits in comparison to last fiscal year, quarter 4. Year to date, the PTBC had 1,468 page reach impressions and 475 profile visits. When looking at TikTok stats for fiscal year 2022-23, quarter 4, PTBC had 27 new video views or impressions and 35 new followers. Year to date, we had 1,407 page reach impressions, 52 likes, and 35 new followers altogether. When looking at Twitter stats for fiscal year 2022-23, the PTBC had an increase of people reached by 38% and a 37% decrease of page engagements compared to last fiscal year, quarter 4. Year to date, the PTBC had 6,527 page reach impressions, 143 engagements, and 12 new followers. LinkedIn had 385 page reach impressions, 90 page visits, and 8 engagements. And then for the year to date, the PTBC had 3,173 page reach impressions, 316 page visits, and 42 new engagements. In total, for all of our followers, for all of our social media accounts, as of now, we have a little over 4,000 for Facebook, 705 followers on Instagram, 763 for Twitter, 45 for TikTok, and 656 followers for LinkedIn. For outreach workshops and webinars during fiscal year 2022-23 quarter 4, the PTBC provided virtual and in-person outreach workshops to 2 PTA and PT programs. And then for the entire fiscal year, the PTBC provided 23 outreach workshops. We also attended the CPTA annual conference in Anaheim last year and hosted the FSBPT annual meeting in Orange County. We do look forward to providing more outreach workshops to PT and PTA programs and are continuing to fill up our 2023-24 outreach calendar. We also just had an opportunity to provide outreach at Fort Irwin on September 6th, which Sarah Connolly and our military analyst, Paul Rowe, attended on our behalf. And then we are looking forward to attending the CPTA's annual conference this year on October 7th and 8th in Long Beach. The summer 2023 progress notes are now out, and I provided you all with a copy to look at. The next edition will be our winter 2023 progress notes, and those will be coming out by the end of this calendar year, so sometime in December. And as we talked about yesterday, the new website is finally live. And that completes my outreach report. Are there any questions?
Thank you, April. Did the Twitter change to X
Yes.
affect any of the Twitter stats?
No, we still have the same followers. It was just kind of like just a flip in the logos and the names and stuff, but it didn't like get rid of any of our followers or anything like that. It's all the same. And the content's still the same there.
I have a question, April. What is your analysis of the effectiveness of our social media campaigns that comes from, like, looking at TikTok and seeing, the low numbers there versus looking at Facebook and seeing higher numbers there?
So when it comes to the followers, I always say don't let the followers trip you up, because the thing with TikTok is even if someone's not following your page, it's still showing up on other people's, it's called their For You page. So as long as they're looking at it and liking it, if you look at our likes are in the thousands compared to our followers are 45. So it's more than just our followers that see our content. So TikTok's a little bit different in that aspect than Facebook or some of the other social media websites.
Yeah, one of the difference that I also point out between the Facebook statistics and the TikTok statistics is the Facebook page alone has been around for quite some time. And so that's a kind of a long-standing collective of the number of people that have liked the Facebook page. And Facebook followers don't tend to unlike anything. It's not like they clear house. They just let remnants kind of stick around. So we reap the benefit of that. And then for the TikTok side, it's kind of a TikTok users don't typically subscribe. They rely on the algorithms that kind of follow them around. And so if they have typically PT-based content in their algorithm, there's a good possibility we're going to show up in that algorithm. Where just habitually, they're not as prone to liking or following or like they are on the other social media platforms. The other interesting thing that I'd point out is that on LinkedIn, we're starting to see new graduates who are adding and tagging us as a new certification that they've received as a result of receiving their license. And so they say, I've received a new certification from the Physical Therapy Board of California, and I'm now licensed to practice physical. And it's an official announcement, similar to something that somebody could say if I've received a certification from Microsoft or something like that, and adding it to their repertoire. And so we're going in behind it and just saying, congratulations, good job, and just to add to that equation. And we're seeing more and more graduates that are using LinkedIn, tag us and adding us to their resumes, essentially.
And I do want to point out with TikTok and LinkedIn, if you're looking at the statistical report, it does show the year-to-year change. It's still 0. It's only because with LinkedIn you can't go a year back to see that data. But now that we have it this year, we'll be able to compare, our current year to fiscal year 2022-23. And then TikTok, we just started it this year, so we have no last year data to compare it to. But again, we'll be able to compare it now that we're in the new fiscal year to the one we just finished. So you'll see that in the upcoming meetings. You'll start to see those numbers won't be zero anymore.
It sounds like there's some fruit from all of the different platforms, so yeah, we'll continue to see that next year. Thanks.
I'm glad we have all of the platforms covered, so. woo-hoo. Any further board comment for April? Any public comment? Thank you so much.
Thank you.
April. Moving on to item number 19, Administrative Services Update from Alicia Hernandez.
Good morning, everyone. Good morning, everyone. My name is Alicia Hernandez. I am the lead analyst for the administrative unit with the PTBC. I will be presenting the budget report for PTBC. PTBC spent 91% of the fiscal year 2023 budget of $7.1 million. PTBC reports end of year 2022-2023 at $6,498,306, an increase from last fiscal year. Excuse me. Fiscal year 21-22 expenditures were 6.4. This is a normal increase. We highlight a decrease, which was attributed to staff salaries and benefits, primarily due to vacancies. PTBC admin unit is currently working to fulfill those vacancies moving into fiscal year 23-24. We did have a positive revenue collection ending the year at $7.2 million, which is roughly about $700K. This is attributed to increases in applications and licensing, which is historically normalized rate of 5.5%. Current budget moving into 23-24 are proposed at $7.2 million. The PTBC is currently working with DCA Budget Office during the galley period to finalize the items to align with a more accurate account for expenditures in different areas. With that said, the PTBC reports no action is required at this time. Any question?
Thank you for the statistics reports. And every meeting, I still find myself really kind of jumping in and trying to make sense of it. Is the reason why temp help expenditures went up because of the vacancies?
So the reason temp help goes up, or where you'll see it, is when we try to build a limited term position in the idea of collecting data for the idea of a permanent position. So as an example, the ADA and IT position, we will start it as a limited term position, which means that we're spending those monies out of the blanket, the general budget itself, not a specific position authority. While we collect that data, we're also building a request to make it permanent, either through a BCP proposal or utilizing some other position authority we may have on book. There is no actual budgeted temp help, so anytime you see temp help, it's going to be in the red. Anytime we spend money out of the blanket, it's a unplanned part of the budget. And so it's always going to be an over expenditure of that line item anytime we utilize that process.
So being in a good position with staff availability and thinking we can fill those positions, this would hopefully look different next year.
You still might see temp help being utilized in the future because, again, anytime that we see a necessity to start developing a BCP, essentially like a good example of that might be not maybe this year but the year after, and we're looking at the increase in applications received and we decide that we want to increase staffing to divide the cases per analyst that much more. We might start with limited term, which is funding from the blankets that we didn't expend elsewhere, and just start building that position to justify its existence, that this isn't just trend data, this is an ongoing issue. And so we'll collect that data through the limited term, essentially spending the monies that we have not spent elsewhere, and then propose a budget change proposal that's something that's a little bit more significant and permanent for an actual PY authority in the future.
I think my question comes from, yes, I realize we're getting more PTA programs. I know they usually don't have the same numbers as PT programs do. However, they're coming in more numbers.
Yeah.
So I think this goes back to my question yesterday of how can we get a sense of, you know, what that workload looks like given the quote-unquote efficiencies of Breeze, the increase in staff, and then the actual workload of what it takes to process, you know, the PTA applications.
I think one of the things that we need to do collectively is kind of settle into those no vacancies, get those seats filled, so that we can kind of really get a true assessment of the impact of now the utilization of Breeze and the efficiencies compounded by the new seats. How much performance have we really shaved off of that, and determine if any, you know, necessary staffing should be planned for any time in the future. There's a good possibility that that may not be the case without further increase in PT programs or cohort sizes or something like that. Right now, with the number of vacancies we have, future planning is kind of on hold. I mean, we really need to kind of get fully staffed first and assess the workload and how we're able to, you know, maintain that workload with the existing staff we have.
Yeah, I think that's why I was asking about what this number might look like next year. Yeah.
And temp help isn't always in applications and licensing. It could be in any other form of the unit. So those are some of the other considerations that we might have. If I had an influx in complaints received or something like that, that's always a way for us to adjust midstream in between BCP or spring finance letter opportunities or something like that. And that's assuming that we have funds unexpended elsewhere to spend. If we don't, then that's not an option.
I have another question, but I just wanted to give the board a chance to ask it on the same topic if there's any other questions. And so my next question is, are you looking at the statistical reports, the expenditure? You probably don't need to, but what we expended in a board member, on the board member line looks a lot more than before, or am I not reading that correctly?
You are reading it correctly. So over the last, well, we've seen a trend over, I would say, the last 6 years that the board member expenditure has always exceeded our allocation.
Yeah.
Typically, over time, that should get adjusted because that should prove that allocation needs to be increased. But we ran into the pandemic, and so we took a little bit of a dive. We saved quite a bit of money on travel and that kind of thing, and so there was a little hiccup in the statistic. I would imagine either this next fiscal year or the fiscal year after, you will see that adjustment being made, and so you'll see less red when it comes to board members, but you'll see a truer display of what should be allocated in the budget for that.
I have a question on that. Am I reading it right? It says 12,000 for the year?
Correct.
What was that based on the previous years? I see that was obviously in 2021, 2022.
And that goes to my point of we've overexpended that particular allocation for the better part of a decade now at this point.
That's what you're saying.
And so it just has been trued up.
Has it?
And that line item in particular is per diem based only. If you go farther down into the material or into the display, you'll see travel, and
Yes.
travel is overexpended as well. And that's not just you as members, but that's also staff. And so that's something else that needs to be adjusted.
That's our outreach efforts,
Outreach efforts, board meetings,
Yeah. Conference, whatever.
conferences
Yeah.
hasn't been adjusted for COLAs or, cost of living expense increases or inflation, no adjustments at all. That's the old number that just keeps carrying over from one budget to another, which we have to be very cognizant of when we're looking at how we spend money. We know that it's under allocated, and we know what a reasonable expectation will be for a fiscal year, so we need to make sure that we under expend a line item to cover it.
Yeah, it looks like we took a big hit in Q3 for major equipment.
We did.
Yeah.
So, and I think we'll probably take a semi-major hit again this year. We're at end of life for a lot of our tech inside of the office when it comes to like laptops. So we will be making purchases for that for warranty reasons and such. The expenditure this year had to do with conferencing materials for our workrooms, Surface hubs, and camera systems so that we could have, so we could prepare for things like Begley Keen adjustments and still be able to do webcam in a box or web meeting in a box.
I think those things have come in common when the actual building wasn't able to accommodate us sometimes for some of those
Yeah,
conference
and
meetings.
staff and I use them on a daily basis. It makes for better collaboration, ease of communication between us and the department and other boards.
Jason, can you tell me, because this isn't my forte, what is the average lifespan of a laptop?
It's funny that you should bring this up. This is like a hot button topic between staff and I. Warranties are typically 3, 4, or 5 years. There was a period of time where the technology really excelled from one model year to another, but we've started to kind of flatline out a little bit. So currently the laptops that we have now are 4 years old and are expiring in warranty and are exhibiting what seems like issues and problems on a daily basis for members of our staff, meaning blue screens of death, not able to charge, Type-C ports not working, those kind of things. And because the warranties are running out, and they're all on different schedules, so we have to kind of do a little research to figure out if the warranties apply to them or not, and if they don't, then we have to make a decision as to whether invest in repairing an existing laptop or keeping that money and just making a bulk purchase and starting over again. So 5 years is probably a fair lifespan.
I think that is fair. I mean, and sometimes it's shorter than that, probably. But my question just comes from perception, because I know, it seems like not long ago we moved and we updated and
Yeah.
but it's been some time now. And I know
we-
personally, I replace mine every 3 or 4, so, yeah.
We purchased laptops shortly before the pandemic, and it was more coincidental than anything else. We wanted to switch from towers just to make for a more mobile workforce, but not knowing what more mobile workforce meant pandemic-wise. We were just talking about opportunities to collaborate, having staff all come into a conference room to do case review or something like that, and not be tied to a tower at their desk. So we made that transition with just a little bit of luck, and it made our transition into COVID and the pandemic a little bit smoother, especially with the move that we did in the middle of the pandemic. But those laptops are the ones that we're talking about now, where we're coming to end of life. And so we're right at the 4 and 5 year mark.
Thank you, Alicia, for your report. I have a question about
Sure.
CMP Services External. Is that Consumer Protection, CMP?
So CMP, an internal or external? I'm sorry.
External. I'm just wondering what CMP stands for.
That is our consumer protection.
So that's something that's just going to fluctuate out of our control.
It will, and just to go back, and I apologize, kind of choked up. Basically what we've done an exercise with the DCA and their budget office. So we are looking at every line item to readjust, because as he mentioned, some of those are not realistic numbers. In working with them, we're going to try to make sure that it's more of an even base versus, because there is red, as you've seen it. And so with that said, we're going to address all areas of the budget in a whole.
Awesome. Thank you for your
You
work.
bet, no worries. Thank you. Any other questions?
Any other questions from board members?
Yeah, I got a question on sort of on the revenue side. I guess really the board is dependable on the assessment of fees and in a couple of major areas. So I guess a question for Brooke is the legislation, the bill SB 816, was that? 816?
The omnibus bill for the
Yeah,
department.
is that proposing to all the departments to reduce the fees?
No, that's just specific to certain departments.
Okay.
Each year, usually DCA has works with the legislature and has an omnibus bill. And it's usually non-controversial language that they address in there. And so certain boards sometimes do a fee increase or a fee revision. And that's approached via that vehicle, the bill vehicle.
Okay, so you wouldn't
But
have any
it does
fiscal
not apply to
impact for us.
PTVC, yes,
Okay,
no.
great, thank you.
I had a question on our totals for reimbursements. It looks like from last year, we have cost recovery investigations like doubled, or is that tripled? Can you explain that line item, any of you?
Keep in mind that line item can be anomalous because when we are imposing discipline or entering into stipulations about discipline, we impose cost recovery or assessment of costs against that bad actor, and we hold those costs against that person. Our ability to collect those costs vary from one licensee to another, right? So you might have a licensee with significant costs, but essentially just enters either into a stipulated surrender or revocation, and the likelihood that we will ever track that money back down and get them from them is nil. Probation is a little bit different in the sense that we can enter into a payment program or take a one lump sum, but those costs need to be provided back to the board before that particular person completes the probation. And so you'll see those numbers kind of fluctuate. We did pretty good this year compared to last year, but a lot of that might be because last year it could be one case really that just had a significant cost to it where that person surrendered, and it would skew that statistic a lot.
And it's probably also timing in terms of where the cases are and when they're, yeah,
Absolutely,
okay.
what fiscal year they're collected in and so on.
So similarly, surplus money investments also rose significantly this year, but I don't understand what that category is.
Yeah, so surplus money investments are monies that reside in our accounts that are also invested and either reap or yield results in dividends, and then we receive back in interest payments. And this year was a good year for us for those accounts that sat, but those monies were used for investments. But that's a department-wide issue as well. So it's not as though we are investing the money, but it's monies that I would consider pro rata expenses. And while those pro rata expenses are sitting with the Department of Consumer Affairs, they're also earning investment income.
That's a good thing.
This year.
Yeah, this year.
Yeah, it
is.
hasn't always benefited us, but
Because
yeah,
I was
this year
looking at
is a
pro
good
rata,
thing.
and so
Yeah.
this is good.
Yep. It did take a pretty good chunk out of it. Pro rata, still pro rata though.
Any more questions, comments from board members?
Just a quick question on, is there a comparative of budgetary control over, to the actual expense?
I believe we put that in the board materials after. There's like, we did the milestones also, the 3-year milestones, and then we did the year over year, so those are.
Okay.
Don't exactly locate that.
Just a little background. So health-wise, we are a special fund. We don't receive any taxpayer money. All of the revenues that we receive are generated either by application fees, renewal fees, or cost recoveries as a result of enforcement cases. So we are allocated a budget typically like other state agencies through GALI, through the governor's office. But that budget is allocated from our special fund, right? And right now, I think we're at about 7 months in health for the fund, and we're living within our means. We're actually taking in more revenue than we spend, and we're underspending our allocated budget. So this year, similar to last year, we had a fairly significant revision, meaning we underexpended our budget enough that we're going to take that money and put it back into the fund condition to be built to budget in the future. And last year, board members might remember, we had kind of sounded an alarm, if you will, by mid-year that we were going to overexpend our budget. And it was a very conservative projection being provided to us when we were tracking our own numbers, we didn't think that we were going to overexpend our budget, and we didn't. We reverted a little over $300,000 that year. This year, we have a similar situation with some of those vacancies that we talked about, salary savings as a result of that. We saw a decrease in our investigative costs and the number of complaints we received, and then a few things like cost recovery and also those invested incomes from pro rata. We're going to put a little over $600,000 back in the fund this year. And so where I typically am okay with 3 to 5% reversion, I think that's a good way to keep the fund healthy. We're at 9% reversion this year.
Okay.
So
Great. There's no requirement in terms of operating transfer back to the general fund or anything, right? I mean, you can keep every penny there.
there's no requirement. But because we are a special fund and that fund condition's sitting there with, as I said right now, about 8 months of reserves, those reserves can be tapped into by the general fund with a loan. And we've had that situation in the past where we let that fund sit there in our own fiscal responsibility, just being frugal and making sure that we had money for a rainy day.
Right.
And the state said, well, you can afford it. So we're going to take a loan from your monies and then pay you interest when we pay you back. And we'll pay you back when you risk insolvency.
Okay.
Or something like that. So
Right.
we still run that risk now, having a healthy enough fund. At one point, we were down to like a 3-week fund condition. We had just enough operating expense in the fund to keep us afloat for 3 weeks, which is really uncomfortable. I wanted a double-digit fund condition, 10 months or more. We had it for a short period of time. I think we're going to get it back a little bit. If you have less than 3 months in your fund condition, that's a time to start thinking about raising fees.
Got it.
If you have too
sorry.
much, then you have to consider reducing fees.
How much liberty does the board have in terms of where to invest the reserves?
None.
None?
Yeah.
It goes to the pool or the
It goes
state
to a
pool?
larger pool which is where we were talking about those.
LAIF
It did well this year.
Okay.
But I think that had more to do with the stock market and the economy than anything else. So,
Got it. Thank you.
Yep.
Thank you. Alicia.
Any further board comments?
I have a question for Jason. At the last FSBPT meeting, they mentioned that there are grants available for various jurisdictions for like enhancing the ELDD and and collecting workforce data. Does the board qualify for any of those, or are we already taking advantage of those services and products that they're offering?
we are already taking advantage of the services and products, and we're making progress towards improving the ELDD and how we share information from one jurisdiction to another. In the eyes of FSBPT, we qualify for the grants. They're more than willing to hand us the grants to make those technology improvements as we see fit. Our difficulty at this point is kind of the bureaucracy or the red tape on this side, on the California government side, of where those grant monies go and who they're paid to, and so on and so forth. So it's an unusual mechanism that FSBPT is going to continue to offer to us, and we're going to continue to pursue it. But it's been kind of a difficult road on trying to figure out how to take free money.
Okay.
So.
Thank you.
Okay, any public comment? Thank you, Alicia. So we are going to take a 10-minute break. I know we're moving through this agenda pretty quickly, which is a good thing. I will be leaving the meeting, and so Vice President Dale Armstrong will be coming and filling this seat. So good seeing you guys, and see you guys again in December. We'll take a 10-minute break.
Just to identify.
Okay, the time is 11:16. We are resuming our meeting after the break. We'll have roll call.
Tanya McMillian. Tanya McMillian is absent. Dale Armstrong.
Present.
Karen Brandon.
Present.
Katarina Elby.
Present.
Samuel Pugh.
Present.
Alicia Benayonet.
Here.
All members are present with the exception of Tanya McMillian, and the board has a quorum.
Okay, we're moving on to item number 20, which is licensing services update, and we have Valerie Kearney ready.
Thank you. I am the licensing services manager. And as you may have heard yesterday, licensing services has a few staff vacancies, 4 to be exact. That would be a full-time position in continuing competency, 2 full-time applications analyst positions, and with my appointment to manager, the full-time lead analyst position for the program. For the past year, PTA applications have been processed by our military and endorsement applications analyst, but the recruitment process for that PTA analyst position, it has been initiated. The recruitment process for the continuing competency position and the other 2 other application analyst position will begin soon. With the staff vacancies and a 12% increase in total applications received, application processing times have increased 27% to an average of 25 days from application receipt to licensure or denial. But that processing time is still well below the target. This is due in large part not just to the efficiency of the process, but also to the efficiency and dedication to the staff. Continuing competency change in resources, the vacancy of the full-time analyst position, explains the decrease in audits performed, but current staff is compensating for the vacancy while approval agency audits continue. The new website, with its ease of navigation for applicants and licensees, will make application submission or license renewal even easier than the previous version. And the homepage posting of licenses issued and application received is a feature that will benefit staff by allowing them to see their numbers in real time. Any questions?
Yes. On, just below the report, there's application services data summary, and there's endorsement versus exam, and then there's U.S. foreign educated and military. And I'm guessing that U.S. foreign educated and military should all add up to 100?
No.
No? That's, okay, so how are we to look at this?
So the endorsement and the exam application should be 100%.
Correct, but.
And then the U.S. educated and foreign educated should be 100%.
Got it.
And then military is just another subsection of those.
So what's the 2%? 2% of what is military?
2% of our total applications received.
So
So
you could have double representation. So
I
you could be
gotcha.
an endorsement applicant and also have military exemption. You could be a U.S. graduate and have military exemption. So, but it's just to give you an idea of the volume of applications that we would be giving that expedite towards.
Okay.
Any other board comments or questions?
Yes.
And I don't know if this would be helpful. I had a couple updates as well to add, if that's okay if I do that, and
Sure.
then maybe see if there's additional questions after.
Yeah.
Okay. So I'm Sarah Conley. I'm the Assistant Executive Officer, but I previously served as the manager of the licensing program. So I'm just adding some information with Valerie. And I'll start with staffing. So the good news is I'm happy to be at the side of Ms. Kearney, who's now serving as the manager for the licensing program. Ms. Kearney was appointed in August and has hit the ground running. Prior to her licensing manager appointment, Ms. Kearney was the lead of the licensing program and evaluated initial license applications as an analyst before that. She brings with her a wealth of knowledge and experience that is a great benefit to the licensing program staff and stakeholders. Now with that, we do have vacancies, as has been discussed throughout the whole meeting. We have Ms. Kearney's vacancy, the CC analyst position, in addition to the 2 analysts for application processing. And that's been discussed quite a bit here, but I do just want to highlight the fact that the 2 analyst positions that we recently received are through the budget change proposal process. So they're new positions, which means new budget authority for the working budget from our fund. So it's not filling an existing vacancy. There's two new positions to help in applications. These positions are slated for the applications unit, specifically for endorsement applicants and military applicants and licensees. While the focus of these positions is for a specific purpose, they will provide benefit for the licensing program overall, reducing processing time and improving service. We had piloted a program to designate resources to the military members and partners, which has proved successful, and we're excited to continue these efforts. So talking about military, as Ms. Beauchamp noted in her report, I did have the opportunity to partner with DCA and other boards and bureaus, and had the privilege of attending an outreach event at Fort Irwin Army Base just outside Barstow with our military liaison, Paul Rowe. It was a pleasure meeting with the service members and their families, discussing licensure, but even more, sharing important consumer information, such as how to verify a physical therapist or physical therapist assistant license, as well as other DCA licenses. Their response was positive and appreciated, and we look forward to building on this outreach opportunity to connect with military service members as well as consumers. A number of the service members and their partners shared that they've had physical therapy or need physical therapy, so they were very interested in learning about the board, about DCA, and verifying licensure. We handed a lot of outreach cards with the Breeze QR code to go verify licenses. For the application data, licenses issued is consistent with our workload output, and we do expect that because our resources we have, there's a certain finite amount of output we can have until we increase those resources. But the applications has increased, as been discussed, specifically in the area of PTA applications. This ties back to that need for additional resources and those BCP positions. Processing time, there's a processing time report in the materials, and the average, this information represents the average processing time of initial license applications, and this is taking out the applicant time. So this is just the time or the number of days that the board is responsible for those applications. And in all areas, we are meeting our performance measure target in processing those applications. So that was discussed a little bit yesterday, that kind of chess clock, applicants, time versus our time. We are taking that into account, measuring that through Breeze, and reporting the information that way. Because we do have, it doesn't, we have a low number of days for processing when there is a change, a lot of it due to resources. You will see that percentage change is larger, and that's just because there's not as much, the number isn't high of the days. So any little impact, it could even be people on vacation. If it increases a day, that could have a larger percentage impact in the change. To add to yesterday's discussion and a little bit today, we were talking about determining resource need, and how that works with growing workload and efficiencies. Whenever we're looking at efficiencies, many of them tied to Breeze and electronic updates, they must be built. So there's a lot of work that has to go into the planning and the development of any kind of efficiency that's implemented, especially in Breeze, because we want to make sure it's functional, otherwise it's not going to be effective. And then also data collection and reporting. As mentioned by Ms. Gear yesterday, we are DCA, it's a big focus for DCA in data collection and reporting, trying to be consistent across the department. Also for ourselves to make sure that we're using the data to make decisions on our progress. And so with these collaborations and assessing our own program, this all takes resources. Also, As is represented in the survey responses for the applications, we need people to help people. At a point, there's no replacement for the human interaction. So all of those factors are considered and balanced when looking at, how many resources we need. So that's it for applications, and then I'll go into the survey report next. If you want me to continue, I can, or if you have any questions at this point.
I do. Your audience at Fort Irwin, were those consumers of physical therapy?
Some of them were, yes.
Okay. In California, not necessarily on the federal jurisdiction?
I can't say for sure where they were receiving their care at, but they did have experience with physical therapy.
And they were
services.
consumers, not healthcare professionals?
Yes.
Yeah.
So we did meet with a couple potential applicants, but most of them were actually consumers.
Okay.
So I think it gave us maybe a doorway into how, maybe a step to reaching consumers, because that's been a difficult area to break into. And maybe, the focusing on military, that'll get us into some consumer outreach, and we can build on that.
Yeah. If an applicant has a complete application online and tests, and you get that, or PTBC gets that score a week later, is the process within Breeze an automatic issuance of license? Or is there some sort of human interaction that needs to happen before that is issued?
It depends. If you want to.
That is, it can be either one, actually. We have, this year again, initiated automatic licensing. It is, it's really great for the applicants who are becoming licensees, but it's very time consuming to set up. That's why we haven't used it on a regular basis, but we tried it again this year to see if we could have streamlined it any, and it's still time consuming. So it just needs more work. But typically, the way we have been doing it is once the applicant, are you talking about the California law or the MPT? Because they're slightly different.
I'm talking if an applicant has everything done and the only thing left is the NPTE score report.
Thanks.
How long does it take for that applicant to receive their
Right.
license?
Okay. So those scores are not available online or to us until a week later.
Yeah.
And once we receive those scores, the analyst begins organizing and licensing immediately. It is done in alphabetical order because that's how we receive the scores. And so somebody whose last name begins with a W, it might take them 2 weeks before they get licensed. But somebody at the front of the alphabet will get licensed sooner.
If theoretically it was set up for an automatic issuance, all of them would be licensed the same day.
Same day.
So do you have any comment about that?
We're getting there.
Yeah.
And that's the end goal. Some of that issue has to do with interface kind of differences between us and FSBPT. And just also to Valerie's point of queuing up the application so that that automation can take place upon receipt of the score is time consuming. It's essentially approving the application with that last deficiency not being fulfilled yet. Maintaining it is sometimes a little bit difficult because now as those scores come in and you have an expectation of license to be issued, you're going to have some fallout. Some of the students may not have passed, not attended even, that kind of thing. So there's just some kind of maintenance around that process that needs to be done. But it's where that's where we're headed towards. The other issue is with those vacancies and some staff kind of taking the workload of other staff, and the example there was, our military liaison, endorsement liaison is actually handling the PTA new grads. When that position gets filled, it'll make it that much easier for us to start utilizing the automated process.
I just want to add to, so to be able to get the data on processing time with taking out the deficiency time that the applicant has, we actually have to enter those dates in. So the analyst is actually manually entering that information in, otherwise we can't get that. So that's another piece of the workload that's associated. So we have to know when they they're able to do it if they know like what exam the applicant's taking. So there are some moving parts into figuring that out. So
Yeah.
that's what we're working on to develop that process more.
Yeah.
But it's not just, it's not as automated as
Right.
it may appear. So,
Yeah, surprises.
It's also a very good example of where the expectation of collecting the reported data slows down the process in and of itself. Right, so that's the part that they're alluding to, is that receiving those scores and now saying that that deficiency has been fulfilled, and having to log that just for the sole purpose of us being able to say the chess clock has started or stopped on behalf of the board or the applicant, now slowed down the ability for us to do the automated process. So.
Any other board comments or questions?
Yes, is there an anticipation still of switching over to the JAM?
Yes. You're just stealing thunder.
Oh,
Right.
sorry.
Sarah and I have been working on the existing JAM bank and working with FSBPT. We have a little bit more to do. Once we get past that point, they will start talking about development time and actual launch dates. So right now, I would hesitate to project a time, but I would say, without speaking on behalf of FSBPT, first quarter of next year.
Ooh.
Thank you. Did you want to go, give your additional?
yes, thank you. And just, I don't know if everyone knows, but the JAM is a jurisprudence assessment module, so it's
Thank
our
you.
law exam. All right, so in the materials, there is a report on the application survey responses, and this is being provided as is one of the measures used to determine if the licensing goal for the PTPC's 2018-2022 strat plan was achieved. Staff had reported the outcome of the strat plan at the March 2023 meeting, so this is just follow-up information. The data collection dates were selected based on available data starting in 2020. Overall, there's a high satisfaction rate with over 90% for both years. So it's harder to increase with that high percentage, but it still did increase 2.56% over the course of that time. And just for clarity of the reporting, that the satisfaction rate does include a neutral response. So if they said that they were neutral in the process, if it was easy, or if they had a positive response or very positive, that's all included in that 90%. And then either a negative or a very negative experience would be excluded from that. So just to go over some of the comments, staff is absolutely a critical part of services. Staff was recognized by name for their services many times. Like I said earlier, people need people, no matter how much automation is implemented. And even with automation, it doesn't eliminate stakeholder assistant needs, it just changes what they are. And then you'll see some example comments in the materials, and you'll see that just about for every positive comment, there's a negative comment on the same topic. And this really is representative of the experience staff has anecdotally as a measure of performance. Each stakeholder's perception of the experience is based upon their individual circumstances. An example of this is an endorsement applicant who may be comparing the license process in another state. So they're coming here and there's more requirements, or their processing time is longer because of our volume, but in another state it may have been quicker or fewer requirements. So their response to that survey, they may have indicated their response was negative, even though for California it was our kind of typical process. So how do we use this information in the survey? How do we use it to measure our performance? We're looking for trends in both data and anecdotal experience shared by stakeholders and staff to identify opportunities for improvement. This happens on a larger scale, such as the strat plan, but also in the program's day-to-day assessments. We are continuously evolving in both small and large ways. An example of a larger change to address a call for change, both internally and externally, is the website. And that was shared yesterday. And with all the considerations that staff had to improve the stakeholder experience online. So we continue to evolve, but we also appreciate the positive stakeholder feedback to support our efforts. And that's all I have for the survey. And then I'll move into license maintenance, if there's any questions on the survey.
Board comments or questions?
So was the survey offered to everyone who was issued a license?
Yes, so that survey is included on every email that goes out to new licensees.
Regardless of what type of way they were coming through the door?
Exactly.
Yeah.
Yep.
And is there a reason why we don't have information for 2021?
So that it's just the change across that time period.
So it encompasses that year?
Yes.
It's just, okay, thank you.
Yeah, it was our baseline in 2020, and then the change based upon any efficiencies or any improvements that we implemented from 2020 to 2022.
But 2021's in there?
Yes.
Yeah, thank you.
I have a comment, but I wouldn't say hesitant. So Sarah and I have had conversations about this particular survey analysis at length. And I'm bewildered by it because there's two things about surveys, in my experience, is that surveys are most often taken by people who are dissatisfied with the services that they received. So this is so overwhelmingly positive that just has to go towards staff. That's kudos and kudos alone, right? But it also makes it hard for us to assess what issues are, any kind of potential improvements may be. And in some ways, so I look at it and I'm conflicted because the data is so hard to rely on, considering what typical survey data should look like,
Are you talking about the respondent rate?
Well, the respondent rate is low compared to the number of requests that we provided, right? Like, here's your opportunity.
But that's a common thing.
That's common, absolutely. But the respondent rate typically would be the people who had something to say negative about their experience. Typically, especially in a state agency kind of way. And here it's just the opposite.
Any other board comments or questions?
Maybe just a consideration for the future to not include a neutral response option. Just something to think about, make them choose one way or the other.
Yeah.
Was there an opportunity on the survey to expand or expound on any of the areas, if they could be specific with maybe
comments,
not their
fields?
positive comments, but their negative? I don't know. I'm just asking because if they could expand on the
I
clarifying.
believe the opportunity was the same for comments regardless of the response.
Yeah, so comments there was an opportunity for that throughout the entire survey, and that's kind of what was summarized in the briefing paper, and that was that it was for every positive, there was a negative, and just depending on the experience the applicant had.
And even in just removing the neutral and creating a lower margin of error, if you will, it's still pretty,
Yeah.
it's
Yeah.
physical therapists are not motivated to complain about their application process, apparently. Yeah. And even in the instance where we talked about the experience of an applicant who thought the process in another state was quicker, some of those states, in looking at them, you have to think about they don't do things like criminal-based background checks, and so yeah, there are some things that are time and tedious for applicants coming to California that are a higher expectation for other jurisdictions. And that's the impact to the process time that they're talking about. They don't understand why that's there. And that's hard to negate too.
Are you, sorry. I just had a question. Are you maintaining the same survey? Are we making any changes for next year? Because I'd also like to know if there's a question about interface with the new website. I think that we should almost take a look, because one of the questions specific to that would be, was the application process easy to navigate? The process is so well, defined now on the new website. I feel like that would be nice to know what the impact of having invested in a better website for people to find information was.
So I think that there's a way, like leaving the survey as is will actually show the benefit in improvement responses based on the website. There's also a secondary survey on the website for non-applicants, licensees, consumers, those kind of things, to fill out a separate customer satisfaction survey. And I think we'll get some feedback on the website through there as well.
And regardless of the return rate, I mean, your unit's to be commended for these results. So work well done, and thank you.
Ready for the next report?
Yes.
Okay. So the license maintenance report, it's all very consistent with what we would expect to see in those requests, renewals, address changes, license verifications, name changes, and duplicate requests. One thing I do want to point out, with our new automated reports, we're still doing some adjustments, and you will see in address changes, processing time. So it's page 100. The address changes, it says the processing time is 0, which means it took less than a day for those to process. And those requests are generally automated. You go into Breeze, the licensee updates their address, and it's instantly done. But the year-to-year change is 166%, and that's because the system is actually accounting for the hours and minutes of those changes, which can be just how long the licensee took to make the change. So in the future, we'll change that to 0, but I just wanted to explain that because it does look, it stands out as 0 to 0 and then that high percentage change. So that explains that piece. And then otherwise, I don't have any other updates for license maintenance.
Board comments or questions? Any public comment or questions? Okay, thank you, Valerie and Sarah.
Oh wait, I still have more.
Okay.
I'm sorry. That's okay. I just want to go over the 3-year data comparison. It's very consistent with what we've been discussing. Applications received is growing at a rate faster than expected. Typically, it's 3 to 5%, and that's with that PTA growth. And then we are seeing the licenses issued being consistent, and that goes back to resources. So everything that we're seeing year to year, it's carrying over for the 3-year comparisons. And this is really, this makes me excited because I like seeing that consistency in the data. We're finding more validity in the data that we're collecting, and that's partly for credit to staff, entering the information, being consistent in how they're processing everything. And so it's just, for us, it's what we would expect. Was there any questions on the 3-year data?
I just want to understand, when you have license status counts delinquent, and it's a moment in time, right?
Yes.
Correct.
When they transition back, how do we, I mean, if they...
We won't know the difference until they get captured at the next moment in time, so the next quarterly report.
So these numbers could be
They
redundant
fluctuate.
in, okay.
Yeah. The other thing that I would highlight this is that you're also very close to hitting your 3,000 cap, right? So 3,000 applications received. We're just 11 applications shy last year of like a celebratory milestone of 3,000 applications received, which is significant. If you look back in time, the 16% difference over 3 years, if we went back quite a bit past that, that number just goes up and up and up, percentage increase. I mean, I can remember 1,500 applications received in a single fiscal year. So 3,000 is going to be a celebration milestone. We're throwing a party.
It'll be on social media.
Yep.
All right, then for continuing competency, I just want to point out that the PTA pass rate is slightly smaller, but that's because of the smaller sample rate. And again, that's due to the vacancy and reducing the sample size to account for resources. But also, we were comfortable with that because of the overall pass rate being acceptable. And then in addition, CC is also auditing approval agencies, so that work is continuing, and lowering the audit sample allows for that work to continue. Even if it's a little bit slower, we're not stopping. So all activities are continuing, and we look forward to filling that vacancy so we can, do more. And that's it. I'm done.
Okay, any board comments or questions? Any public comment or questions? Okay, thank you, Valerie.
Thank you.
Okay, next we are on item number 21, Consumer Protection Services Update. Carol Phelps.
Board members. Now it's on. Thank you. Good morning. My name is Carol Phelps. I'm the manager of the Consumer Protection Services Program, and I will be presenting the update for this program. I'll just quickly highlight some of the details that were shared in the briefing paper that is attached to this agenda item. First, I will address vacancies, as that has been a common topic. At our last board meeting, we had 2 vacancies. We have since filled one of them. As of July 1, Angel Otley has joined our team as our newest enforcement analyst. Ms. Otley most recently worked in the board's continuing competency unit, and so that's the vacancy that they were talking about in that unit. But she is very quickly becoming familiar with the enforcement investigation process. Her past experience in the continuing competency unit as an applications analyst have definitely been an asset to our unit, and she has really hit the ground running. She's been able to relieve a good deal of the other analysts' excessive caseload. There's still a little bit of that left because we do have one other position to fill, which we are in the process of filling now. We continue to have regular meetings with the supervising special investigator over to the Division of Investigations Enforcement Support Unit. The Division of Investigation, or DFI, conducts field investigations for complaints for the board, which includes things like site visits, interviews, the issuance of subpoenas when necessary, obtaining certified documents, and so forth. The purpose of our regular meetings with DFI is to have an open line of communication between the board and DFI to discuss urgent or high-profile cases, as well as other enforcement-related matters that may impact both the board and DFI. We also continue to hold regular meetings with our Deputy Attorney General liaison with the Attorney General's office. At these meetings, we discuss and get guidance on specific cases and review and make improvements to various procedures and to the overall discipline process. Regarding the CPS statistics report that is attached to your board meeting materials, I believe it's page 105. I'll just briefly point out a few details, and then obviously be open to any questions you have on that. Performance Measure 1 reports the number of consumer complaints and arrest and conviction reports the board received last fiscal year. That has increased by a total of 41 cases from the previous year. Performance Measure 3 measures the average case age in days for all cases that were closed without referral to the Attorney General's office for formal discipline. The average for those was 157 days. That's actually down 23% in comparison to last fiscal year. And we're now meeting our target, which is 180 days for this performance measure. Obviously, it's hard to guess or say what the factors are that contribute to that. There's a lot of things in play. Obviously, even with our vacancy, so there's been a lot of improvements to process. Obviously, vacancies filled in other areas like DFI have contributed to that, and possibly more simpler cases. You know, a lot of cases that may have gotten closed much quicker than normal. So, a lot of different factors affected that. Performance Measure 4 reflects the average number of days to complete investigations and enforcement actions for complaints that are transmitted to the Attorney General's office for formal discipline. Case aging averages for this performance measure have increased compared to last year. However, as I've said, these averages fluctuate regularly due to multiple factors, including analyst caseload, case complexity, and the timeline of other involved parties like DFI and the Attorney General's office. The increase could also partly be due to cases being completed in this quarter that have experienced pandemic-related delays. If you look, it's on page 106, the second page of that report. In the total orders, aging, final decisions, kind of the last part of that page, 32% of the cases that were closed did age over 3 years, which puts them back to starting, 2020, when not much was going on at that time, investigation-wise. Attachment B to this report is a 3-year comparison for our performance measures. Most notably, the number of complaints received has steadily increased over that 3-year time period and is now approaching the pre-pandemic levels. We're not there yet. I think over the few years prior to the pandemic, we were averaging 600 to 700. But we're getting kind of back up in that range now. Other numbers have fluctuated as is to be expected, but CPS staff continues to focus on completing the investigations of older cases as quickly as possible, while also diligently investigating newer cases. And I would like to say that our enforcement staff is extremely experienced and extremely motivated to be on top of their caseload. Really, really experienced and really intelligent staff that we have in enforcement unit, and they are doing everything that they can to keep these cases moving. And then finally, attachment C to this report is a disciplinary summary of all disciplinary actions taken by the board in Q4 of last fiscal year. 1 licensee was issued a public approval, 3 licensees were placed on probation, and 2 licensees surrendered their license through the disciplinary process. This concludes my report. I'm open to any questions you may have.
Board questions or comments?
Carol, do you still feel that the meetings with DFI and the AG's office are helpful in pushing things along?
Absolutely.
Yeah.
Yes. We're not having them, I think the intent was to have them monthly, and we do still try to keep that on the horizon. And some months we don't end up needing to have that meeting, but it is we're having them frequently, and they're very helpful.
Public comment or questions? Okay, I believe we'll move on to item number 22. Carol Phelps.
Thank you. Agenda item 22 is a probation monitoring program report. During the last quarter of last fiscal year, there was a high of 80 licensees on probation. Of that, 62 probationers were actually actively practicing in California. The remaining, my math is not right here. Just hold on a second. The remaining 10 probationers were tolling, meaning they were not receiving credit toward the completion of probation because they were either practicing in another state or not currently practicing. I think there's 10 probationers that were not practicing and tolling and were living out of state, and another 8, which brings our math correct, were tolling but living in California. 1 licensee was placed on probation in the quarter, and 4 licensees completed probation in the quarter. Of the 62 licensees actively practicing in California, 8 were enrolled and participating in the board's drug and alcohol recovery monitoring program, which is called Maximus. 1 licensee enrolled in the Maximus program in the quarter, and 1 licensee completed the program. There were 0 instances of noncompliance with probation in the quarter. For the entire fiscal year, there were 2 instances of noncompliance with probation, and both were for not following the requirements of the Maximus program. Over the past 3 years, the number of licensees on probation has increased significantly, going from 57 probationers in fiscal year 2021 to 80 in fiscal year 22-23. In that same time period, the number of Maximus participants has decreased significantly, going from 13 participants in fiscal year 2021 to only 8 in fiscal year 22-23. According to the statistics gathered by Maximus, this trend seems to not only be consistent with other boards that also utilize Maximus, but seems to be consistent with other similar programs nationwide. This concludes my report for probation monitoring. Please let me know if you have any questions.
Board questions or comments? Public comments or questions? Thank you, Carol, and for all your work.
Thank you.
We'll now move on to item number 23, which is public comment on items not on the agenda. Any public comments or questions regarding items not on the agenda?
I have one. Usually there's an item that says, items for future meetings. There's an agenda item for that, but I don't see that here.
You can include it here, though, and we'll
Okay.
record it.
Well, I think based on what I've heard this meeting, I'll wait. Thank you.
We'll move on to item number 24, which is adjournment. Let the meeting notes reflect that the meeting is adjourned at 11:56 p.m. Thank you, everyone.
Thank you.